I have distributed a paper yesterday, which is about 15 pages, I'm sorry. It gives you a lot of anecdotal examples of what the convention is all about, but not just the convention alone, but how globally this convention get into its current shape. Often when we speak of convention or a global norm-setting document, we often tend to speak of the convention purely from the basis of the articles that we read in the conventions and try to apply it in the domestic law. We critique the domestic law, how far it has not been complied with, how far the states have ratified it, how far it is implemented, and so on. But I think it is much more easier to understand the rationale of the convention if we go through the historic process that was involved in the formulation of the convention, or that ended up in the convention on the first place. So to understand the political dimension, the realities behind what it implies by a convention, whether it is torture or the ICCPR or the ICESCR, and the basics of those principles being applied at the domestic level, I propose that it is much more an interesting journey if we try to understand it from a very historical perspective of what torture is, why is it considered today as a heinous crime or one of the most heinous crimes, why internationally it is seen or is looked at or looked down as an offense that calls for the highest forms of punishment, why regimes are condemned for engaging in torture. And that is an interesting journey, or that journey would be interesting if we understand how torture was seen, used, how it was condemned from time immemorial. So I have a few slides here. I'm not a very technology person, so I will try my best to move it through. Now here you can see a poor fellow being hacksawed right down in his middle. So this is one form of torture that existed in the past. It might be gory to see, even though it is a graphic depiction, but then the sophistication in technology, the sophistication in science has developed so much that the pain that this fellow might go through by comparison to the pain that poor people today would go through after being subjected to torture is by no way comparable, because today the pain inflicted by torture is much larger, much long-standing than what was possible some centuries before. How do I move to the next slide? Over there. Amila, can you help me, please? Next one. Okay. We will do this one. This is another form of torture that existed in the past, that also exists today. We have documented cases which involved this kind of torture. Even as we speak, I mean, this is an incident which kicked on from Nagaland, and our friend Anjuman, who's not yet here, from Assam in India, would have heard about, because it was still, or it is still practiced in various forms, even upon children in the northeastern parts of India, and I guess also in other places as well. Now, torture convention speaks about inhuman, degrading treatment as well. So this is another form of torture where the person would be shackled with the hands or legs put in between these wedges and will be exhibited in public. So that is torture, and also this is an old relic, a picture from somewhere in the UK. And it has been practiced across the world those times. This is another form of torture where it's not that clear, it's a painting, where the person here is held back by a fellow, and then the other one has a screw device which is tied on the shin, and it is tightened depending on the intensity of the questions. And you have people marked, so one and two, the one at the back and the one at in the front, are people who inflict the amount of torture. And the one who's sitting on the side, it's a poor copy of the picture, I'm sorry, is an inquirer who inquires into the process. And he decides how much extent of pain should be inflicted upon the person. I will come to that later. Next one. Thanks. So here you have an assortment, a buffet of torture instruments. This one is used, it's called a maiden. And this is a door, and it has spikes inside the door, and also spikes inside the whole canister. And the spikes are so, you can see the spikes already. And the spikes are so positioned that it would not hurt your vital organs, so that the person remains alive for a prolonged period of time, so that the pain goes on. And of course, other tools of pain. Okay, we hold here. Now, you can read details in the paper, but what I have said in the paper is this, that the concept of torture, and obviously the resistance or the opposition to the use of pain, is something which dates back many centuries or thousands of years before than what it has been otherwise conceived commonly, that there was a period of time in medieval Europe where torture was used extensively, and then came the Enlightenment period where individual freedom was recognized, and then gradually getting into the realm of jurisprudence as well as political theory, and then gradually condemning torture. That is true to that part. But then there is also a history which dates back much more than the medieval Europe or the 12th century or the 11th century Europe, which also takes in its sweep parts of Asia, because torture was practiced across the globe, and it existed wherever the concept of state, in some sense, as a kingdom, as an empire, as a principality, as a small fiefdom existed. When I did some inquiry into now how far can we trace back torture and how far can we trace back the resistance against torture, I came to know that it is referred in the Vedic period. Vedic period, I'm talking about 2000 BC. And I have provided references where you can find it as to the fact that torture was used for political purposes, for religious purposes, in such old times, and it was equally resisted, perhaps not with the same refinement that we have for the resistance today, the kind of reasonings that we have for the resistance against torture today, but for purely on a humanitarian ground, purely on religious beliefs. It was referred to by Lord Buddha at the time when his preachings, his teachings were being summarized into samhitas, and it was widely advised or widely preached that torture as an instrument of oppression should not be used, and Buddha had his way of reasoning it, saying that, well, a tormentor would have a tormenting life. And today we have science to prove that a torturer who engages in acts of torture lives also a tormented life, because it is psychologically a very serious issue that affects a person who engages in torture. Today we have scientifically proven articles and studies which shows that a person who suffers torture and a person who witnesses torture suffers the same extent of psychological pain, mental agony, more or less at the same degree. So This is something which was said by Buddha for a completely different reason, perhaps not with the same understanding of psychology as we have today, according to modern science, but that existed, that reasoning existed. Later, when after the Kalinga War by Emperor Ashoka, when he converted into a Buddhist and adopted Buddhism as the state religion, which was a political reason rather than a religious reason, because there were so many Buddhists around in his huge Magadha empire, and he thought that the ill will that the society had formed against the emperor because of a tremendous loss of life during the Kalinga War could be somehow excused if he adopted Buddhism as the state religion. And then, of course, he went all the way out to propagate the religion, of which the remains that we can find even today in the old Ashokan Empire, which includes most of India, or all the entirety of India, including Sri Lanka, parts of China, Afghanistan, Pakistan, all these geopolitical states as we call them today, or as we identify them today. So he said, in fact, he actually proclaimed that torture is something to be condemned and not to be practiced. Of course, for a religious reason, of course, for a political reason. And in page 3 of my paper, I have referred to a particular proclamation, which is Proclamation 13, issued on 257 BC, where he says, if it happens that some individual incurs imprisonment or torture, and when the result is his imprisonment without due cause, many other people are deeply grieved. In such a case, you must desire to do justice. So you can see the concept of justice also evolving at a very early stage. That is, I'm speaking about 257 BC. For this purpose, has this scripture been here inscribed in order that the administrators of the town may strive without ceasing, that the restraint or torture of the townsmen may not take place. So it is resisted by way of if we translate it today as an executive order, as the order of the government of the day, prohibiting torture. And then you can see the same reflection or the acceptance of torture, or the use of torture, the use of force, brute force, across the globe, across the so-called civilized globe, or the so-called civilized world at that point of time. It was used in China. If I dare pronounce a Chinese word correctly, it is Tianzu. Is that correct? Tianzu, which is to keep bamboo in between your fingers and tighten it. It's a practice which was followed across centuries from the earlier Chinese dynasties. It is documented, because the Chinese are very good in documenting what they did and what they did not do, through the communist spirit. And I guess it is even practiced today, unless someone corrects me. It was practiced there. It was practiced in China. It was practiced in Japan. Japanese, what they did was they made a person tied onto the wall, shackled to the wall, and then he was injured by whipping, and then he was kept in a locked room where there were a lot of rats. And the rats were, this is a gory explanation of what happened in the past, but I think our governments are quite capable of doing much more worse things today. So, I can see faces like, what is this? But our governments do this. Maybe not in this crude form, but in a more sophisticated form. I will come to that. So what they did was they heated on one side of the room, so that, fearing of heat, the rats will slowly start moving away from the heat. And this poor wretched who was shackled to the wall and cannot move, the rats will slowly eat the person, because that bleeds the person, and they get some comfort out of the wet environment that injured human body creates for the rats, of course. But then this was a form of enquiring or punishing people who were suspected of engaged in what is called the anti-state activities. It was also used, the use of torture was also delegated to governors. Say, for example, in the Persian Empire, Darius I, who established the Persian Empire centuries before, he had a gang of governors called satrapas. These are people who enforce the writ of Emperor Darius across his empire. And they were allowed to use, and they were expected to use torture, if at all they come to doubt the commitment of a person, or if that person is engaged in any suspicious act which they thought as being anti-emperor or anti-state. So you can see, so many examples of what torture is, and that brings us a leap ahead into the early stages of modern Europe. This is Innocent IV, not so innocent as his name proclaims, who issued the first official papal bull requiring people to be tortured as part of Inquisition, as part of dealing with heretics. History is filled with documentation before the bull and after the bull, papal bull. Now, the fact that the Pope issued a papal bull simply means that torture was so prevalent. The heretics were dealt with crude forms by crude forms of torture when they were inquired into. And the papal bull, which he issued on 15th May 1252, that is the date on which this document was issued by the Pope. It means that it gave official sanctity to the use of torture by inquirers. Now, if I skip back a little, one of the areas where torture was used in an early period was during the Greek and Roman civilizations. During the Greek period, they used extensively torture to maintain the empire, and the Romans just followed that. And in Rome, obviously, all of you know that there is a Roman citizen, and those who are not citizens, mostly slaves. Excuse me. And when a trial happened, this is also the stage at which we see the beginning of the structured processes by which the concept of proof, the concept of trial, the concept of a judge, adjudication started also coming out in a more structured manner. It's a very, very loosely structured one, but still it was in a structured form yet, as opposed to how it was being done before. So when a civil or a criminal dispute happens, the claimant or the defendant, the petitioner or the respondent as it is today, or the prosecutor or the accused as it is today, will have to produce evidence. And the evidence that was often called upon was the statements of slaves. The problem with slaves during the Roman period was that they did not have the right to citizenship. So there was no way by which they could be punished other than torturing them. So even if a slave is willing to give the statement, give the witness testimony, the slave was still tortured to make sure that the statement is correct. We practice it today. I'm talking about 500 BC, and in 2013, our law enforcement agencies still use the same thing. When someone is arrested, if that person, I can assure that Ashok can cite n number of examples where people have been suspected of having engaged in anti-state activities, what the Indian state would call as Islamic terrorism of various kind. They get tortured because the state also would want to get a few other names of people. Now he had brought a book which has just gotten published. I guess there aren't enough number of copies, but that is a book, that is a collection of cases from one particular state in Madhya Pradesh where people were arrested, taken into custody, tortured at length, so that the names of the accomplices would also be spelt out. So what was done by the Romans to their slaves is today practiced by Indian state on its citizenry. I guess it is the same thing that is happening in many of our countries, or almost all of our countries. So here, why I came back to the Roman civilization was also to say this, that at the earlier stage where it was used only to deal with people of inferior quality, like the Dalits in the Indian context or in the subcontinent's context, where it was practiced against the slaves in the Roman Empire period, it slowly started getting used to quell political dissent. So the distinction line, the dividing line between the slaves being tortured and the non-slaves being just questioned and expected to, support their witness testimony by a tortured slave's testimony, moved off to the extent that all Roman citizens, unless you are of very high military order, was susceptible to torture, which is today the case as well. But then there was also a Roman jurist called Ulpian. He said, the use of torture, whether it is a slave or a Roman citizen, is dangerous and deceptive. I'm quoting from his work. He said that it is dangerous and deceptive because he knew that the moment you threat a person with the presence of the instruments that we saw before, or with the stories of persons who were tortured before, or the corpses of the persons who were tortured before, you tend to say whatever that the inquirer would want, which Beccaria at a later stage emphasized by very clear terminologies that, well, it is a method by which there is no way that you can guarantee that the exact truth would be divulged. Because according to him, if you are a strong, hardened criminal, the fact that there is a possibility of torture is not going to budge him or her. Whereas if it is an innocent person, a poor, wretched peasant, or somebody who cannot withstand pain, the fact that the person is getting tortured would be good enough for the person to say and admit whatever that the inquirer would want. So the concept that existed at the time, which is proof by torture, which is called as quote-unquote queen of proof, this is how it was referred to. The proof by torture was considered to be the queen of proof. Because by then the jurisprudence on the use of torture also had evolved. The jurisprudence on torture, I mean, it is strange, but then today we clandestinely practice it in much more sophisticated manner. I keep repeating this, but this is a fact. The jurisprudence of torture was this, that doctors were employed to see how much pain should be inflicted. For example, there is one slide of early modern day China, which dates back to 1910, 1905, where a person will be publicly hung and then will be, cut in public, bit by bit. And a medical doctor will supervise the ceremony, and it is done in public so that the person just doesn't die over an hour or two. It goes on for months in some documented cases. It went on for months. A person has been, like a butcher chopping off meat from a dead animal's leg or part of a body. A human being is sliced bit by bit at a time. Model punishment, asking questions, gathering proof. So the jurisprudence on torture implies this. What is the extent of pain to be used? Who should monitor the torture process? There will be the presence of a doctor. The concept, the entity like the notary became established in Europe by that time. So a notary would be present who would meticulously take down the statements and questions. The judges were given directions as to who can be tortured. A judge presides over the torture process. Who can be tortured, who cannot be tortured, to what extent a person can be tortured, whether a pregnant woman can be tortured, whether a child can be tortured, and if so, what is the extent? What are the tools that need to be used? Things like that. They were prohibited from using tools that were otherwise recognized by the orders or the jurisprudence that had developed during that time. So it also while the complexity or the sophistication of torturing people advanced, it also on the sidelines, or it also on the mainstream advanced the jurisprudence on what is acceptable and what is not. Because the concept of proof, concept of consistency in proof started developing in the jurisprudence. Beccaria says that, well, one of the problems with using torture is not only that some people easily confess and some don't, it also lacks consistency. For one particular offense, one person would say like this at the time of torturing him, and later, when he is questioned again, he might say something else. So there is no consistency as to what a person would say under duress and what a person would say without the threat of torture. So he said that if you are seeking for doing justice, if you are looking forward to see that some form of justice is done, this is definitely not the way, because he was thoroughly sure that this is not going to have any form of firmity or conclusiveness of proof. It was also a theorized which challenged or which set forward in more logically recent argument the concept of equality before law, even though it is not exactly spelled out. Now what he said is this: the crucible of truth. So he is arguing against torture. The crucible of truth, as though the creation of truth lay in the muscles and fibers of the poor wretch. He was saying that it doesn't exist in a person's capacity to withstand pain. It has to be proved the other way around, which is by surrounding facts, circumstances, and so on. And he concluded in his magnum opus, which is on crime and punishment, which is written in a completely different language, but it is now free translations in English are available online. He said that the use of torture is a sure way to acquit a robust scoundrel and to condemn the weak but innocent people. And this was actually accepted because that is also the time when the concept of individual rights, the concept of equality, the concept of people are born equal and not born as criminals also started getting debated, also started getting established in trickles, in small forms, but yet it was very relevant insofar as the development, the historical development of the jurisprudence concerning torture was getting developed. Can we go to the next slide, please? This is this magnificent fellow, 1764. All that we see in the Convention Against Torture is something pretty much that he has concluded in his book that early. Wait, I'm going back. Huh? Okay. This is the Chinese version of torture. A man is hung and he's being chopped. Okay, now we get to this infamous period of the World War. This is not actually an incident of torture, but then the person who was saved from the camp is explaining during the Nuremberg trials to people and to jurists and people who are gathered around to show how he was tortured. So he was held, he was tied to both legs of the stable, he was stretched and his arms were tied here. It is a documented case in Nuremberg trials. And then one after the other, the fingers were being cut off. It was a form of punishment rather than an inquiry by the Germans. This is also the baby Bush's predecessor, which is a Chinese version of waterboarding. A person is tied up and then water drops. There are two versions of this. One is to drop water one trickle at a time, one drop at a time. After a few hours, it is just water dropping, but it is documented that it feels like a bullet passing through your head. After a period of time, you can't move your head. That person's head is tight to the rod, which is behind. Arms are tight, his body is tight, he can't move. And then in that wooden bucket on top, there is a pipe which comes down, and it drops just one drop at a time. And if you sit like that without being able to move the head, and the drop of water falls exactly on the same position over like 3 days or 4 days, each drop starts feeling like a bullet passing through your head. So that is, the sophistication in employing torture over a period of time also developed the same way the jurisprudence on torture developed. So after the Second World War, when the gory incidents of torture and torment was exposed to the whole world, we start getting the debate on the recognition of an instrument called the Convention Against Torture, or a global recognition against torture, even though it was not an instrument by then. It took almost 20 more years, or close to 30 years, for the convention to come into being. But then lot of consensus arose. Science developed to the extent to which people started saying that jurisprudence, the trial process, got more sophisticated, that people started completely refusing that, well, you can't get a person to come and talk and accept what he says because he has given that evidence under or that statement under duress. The concept of self-incriminating, or the prohibition on self-incriminating evidence, developed in its fullest extent, that people started refusing the statements, confession statements, pretty much in all sense. We had been referring to the prohibition on self-incriminating evidence on several occasions yesterday. And later, obviously, the consensus developed into a global opinion against the use of torture. It had a lot of, I have referred those things in my paper. It had a lot of reflections on the global politics that played immediately after the Second World War, the communist bloc, the Soviet bloc, and the non-Soviet bloc, and the way the US-led non-Soviet bloc fought against the Soviet bloc, the use of torture. And one of the characters that, I will skip a few slides, comes into picture is this honorific fellow, Andrei Wyszynski. He was the inventor of show trials during Stalin's time. I can see our friend from China smiling. Show trials, the concept of show trials still exists in many jurisdictions. During once the Second World War was over, there was a split down right in the middle among the Allied forces as to what should we do with the war criminals. So Churchill said, give them 3 minutes, say hallelujah, shoot them. That's it. It's a humongous expense to undertake trial and bring them to court and then prove the offense. You got to establish a tribunal and so on. Roosevelt said, no, this can't work out, because Roosevelt was much less a politician in that caliber by comparison to somebody like Churchill. So Roosevelt said no. Also for this reason, that we cannot be the generation that will be looked down by our future generations if they come to know that we did this. We went to war, we caught them alive, and then we gave them 30 seconds or 90 seconds and we shot them dead. Let us establish a tribunal. The one and only person who agreed with Churchill was this fellow. He was the foreign minister for Stalin. He said, don't worry, let us hold, not with Churchill, with Roosevelt, don't worry, let us hold the trial. Because he knew bloody well that how we can organize pre-judged, decided cases. He said, we will hold trial, don't worry, no problem. You can invite the press, you can invite the experts, you can invite the jurists. We will hold trials. Let us have Nuremberg trials. And that is how Roosevelt, from a completely unexpected source, got support to hold the Second World War tribunals. Churchill was isolated. He knew how to manage this. We still today practice what Wyszynski invented and practiced in Russia, Stalinist Russia, in our jurisdictions. Okay, now if I go back to the slide, I need to be conscious of the time, which I have taken a little more. Now what you see here is the dark colored, I'm colorblind, I'm sorry. So whatever that looks dark is the area where the countries where Convention Against Convention Against Torture has been ratified. This is my honorable country. Sorry, the map was created before Pakistan ratified torture. So, but this I hold true. I mean, India still has not ratified the convention. But we follow a different principle, which is this, which again goes back to the reference to Stalin's Wyszynski. Because when the Torture Convention was signed, India said, yes, we need to have a global norm to eliminate torture from the face of the globe. We signed it on the day the convention was proposed. And we said further that our legal systems are far advanced, so we don't need to ratify the convention and make a separate law because our Supreme Court and the other courts and the Criminal Procedure Code and all these documents are good enough to deal with torture. Of course, in 2012, we came out with a law. There is a huge critique that we have developed on that law, which is 262-word long legislation, which is passed by, we have two houses, we have a bicameral legislature. We have two houses in the Indian Parliament. The lower house has passed it and sent it to the upper house. We send out as many critiques of the law as possible to the upper house, and then we got a parliamentary review committee to review the bill. They said that, well, this can't be a law against torture, we need to rewrite it. So it is stuck at that level, but you can see it is globally accepted that torture is not acceptable. But of course, the question remains as to how many countries do actually practice torture and have put that effectively into practice. So this is basically a snapshot of what the convention is about. It was drafted on 10th December 1984. There was a declaration dating back to 1975, which was a little more sketchy regarding torture. So for example, there are certain concepts which now we find in the convention, which was not there in a declaration which predated the convention. It came into effect on 26 June 1987. There are 154 parties, including India, that signed the convention saying that we should have a global standard for that. And we have 82 signatories actually, because this is before Pakistan. I just noticed that when I saw the map. 82 signatories to the convention, which is ratified the convention, which means that it is domestically applicable. These are the candidates from Asia. It's not a great picture. You have Afghanistan in 87, Bangladesh in 98, Cambodia, which has ratified pretty much everything in 92. China has ratified in 88, Indonesia 98, countries like that, Mauritius 92, Nepal 91, Pakistan in 2010. So by this slide I caught up to reality. Sri Lanka in 1994, and there is a law against torture, which criminalizes torture in Sri Lanka, Act number 24 of 1994. In Sri Lanka, Thailand 2007, East Timor when it became East Timor in 2003. These are the 4 countries where there is a law which specially addresses the question of torture, which prescribes for processes that need to be followed for complaining, investigating, prosecuting, adjudicating, punishment, compensation, and so on and so forth concerning torture. But despite ratification, despite having a law, this is actually what happens in practice. This is a picture from Bangladesh, where I guess our friend, he's not here today morning, could explain further about what happens if you become identified as a political opposition supporter or a person who falls into the wrong hands of the military. This picture is emblematic of what pretty much happens as executive government in Bangladesh and in many of our states. This is a torture victim from Sri Lanka. You can see the marks on his back after being tormented, tortured, brutalized. This is a case in which actually he has lost hearing also because his eardrums were broken after being slapped heavily. This is Thailand. This is a form in which people get tortured in Thailand. And this is a picture taken from actually a museum in Thailand, how a person gets tortured. Nepal. This is a prison in Nepal. I mean, not a prison, it's a police station in Nepal. And this is how under trial detainees are being held. So once in a while, when there is water and electricity, the cops would just, pump water upon the people so that, there isn't any toilet or any other facilities inside detention centers. So they answer nature's call in the same place where they are held. And I have been to a couple of detention centers in Nepal, and it is appalling. I mean, it's a place that you really don't want to be. Men and women are held in the same cell for n number of days. I mean, there is no prediction as to when you will be able to get out or not. And you're stripped almost to just a trouser or a pant, and then you leave like that. I've been to a prison not a prison, a detention center, which is associated with the police station in Kathmandu, and this is the scene what we saw. And that long thing that this person is holding, this cop in the uniform is holding, is a pipe which is getting ready to be used to spray water. This is India, and this is what Kikon was referring to, world's largest democracy. This is what world's largest democracy has reduced to. This is a documented case. It was broadcast live or little later across the country. The guy on the motorbike is a cop. The people have rounded up a person who is suspected of theft and calls the police. The police comes. YouTube videos, I mean, different forms of it, of the same incident, of course, are available. So you can use you can watch it if your conscience allows, and if you can stand the witnessing torture, because it can also psychologically affect, even though we are seeing it in a TV or in a computer. So this guy was tied up. He was suspected of theft. People started beating him up, and the cop came and he said, "Okay, tie this fellow to my motorbike," and he started driving the motorbike. Like in the old Roman days, where somebody will be tied to a chariot. This is what the so-called democracy is in actual practice. This is how things work, and this is how things work in my country. So that is India, which said that there should be a global standard that prohibits torture, because a lot of countries engage in dictatorial practices, and torture is used to silence political dissent. So there should be a global document, and India supports this. You should see, actually Denmark is a country which opposed the formation of the torture convention. It is there in the UN records. But India was one which said that no, there should be a convention, and we should prevent torture globally. But this is from 2012. So 84 to 2012, we have not changed much. So you are right, Ashok, when you said that we just had a change of guards in New Delhi. This is what the British did in a more cruder form, because the facilities available to them at the time was crude. But now we have replaced perhaps a horse with a motorbike. So that is development, if that is it. This is Indonesia. These are Papuan people who get tortured, men and women. There is enormous database on Indonesia, which is perhaps posted by or developed by people who support the work in Papua, which shows various forms, various documentation of how police and the military brutalizes people whenever they are suspected of having engaged. This is Pakistan. where someone has been beaten up, and you see one guy taking notes, and the others are engaged in the act of getting this person to speak what they want. This is the Philippines. There is contest that he was actually fired upon, not really tortured in a way that they were expecting him to be alive. But this is a case that we have documented, and this is what has happened to a person's body. This is Burma. This is not actually a case where the person is actually tortured at the moment when it was documented. She is getting treated after being rescued from a detention center. So you can see how her fingers is bleeding, and you know, all over her body you get blood. Okay, now if we run to the convention, I think one of the most important part that we need to keep in mind is how torture is defined in the convention. It means causing pain or suffering to seek or obtain information, which includes confession, from that person or a third party by the state agent or under the instruction of the state agent. If all these categories are met, or if by and large these categories are met, then the offense becomes an act of torture. Unfortunately, the convention, neither the jurisprudence that developed later, doesn't cover non-state actors, but there is active debate that is going on to see to what extent non-state actors, because Kikon can tell you stories where the militant groups working in the northeast of India are engaged in all forms of torture. So basically, Article 1 of the convention is one document that we have to go through thoroughly, which pretty much spells out what amounts to this act of crime. What is this crime about? Article 2 which is the next portion of the convention, which we have to politically, legally, practically assimilate, which is what the state is tasked with, the responsibility of providing effective legislative, administrative, judicial, or other measures to prevent acts of torture. Now, this is what I want to get at when we discuss about the convention. If we introspect of our own investigative apparatuses, I can tell you for a matter of fact that in India, we simply don't have criminal investigative processes or facilities that fits to serve what is otherwise considered as a modern democracy. It takes at least 10 years to prove a fingerprint. We simply don't have any kind of forensic facilities which is available to what in India we call as Aam Aadmi, the ordinary person. Police officers are not trained, they are not informed, they don't have the capacity to undertake scientific investigation. So I'm 100% confident if I say I'm speaking this in the presence of a former human rights defender, now active politician, a member of the state legislative assembly, and a well-known, well-quoted Supreme Court lawyer from my country, Ashok, that today criminal investigation in India simply begins and ends with an extracted confession. The government has been criticized, the investigative agencies have been criticized to say that, well, we have a very low conviction rate. So what did the government do? They went on to change the procedures, to change the safeguards that existed in the law, to take away presumption of innocence, to take away the right to silence and so on. Well, luckily, because of resistance, it was not implemented into effective law yet. But that time is not that far. We were accused of having only 4% conviction rate. So we wanted to increase the conviction rate to say that India is a safe place. So they decided to take away all these safeguards. This is the principle put into practice in a completely opposite direction as opposed to what law enforcement agency should be in a modern democracy. So the state, if it doesn't we discussed yesterday about what kind of resources are available to law enforcement agencies, how many, now I'm sure that, including the Philippines, that the people judge ratio, the number of judges that are available to adjudicate disputes among the population is far below than what it is actually required in all the countries that is represented here. Perhaps Denmark or Canada might be an exception, but I might have to change my opinion after having dinner with you yesterday. But anyway, I'm sure that none of our countries have enough number of judges, enough number of prosecutors. Prosecutors is a completely different story altogether, but enough number of judges to adjudicate cases. So Article 2, even if we ratify the convention, it is not a mechanical process. In letter and spirit, it needs to be translated into acts of what the state is, practicing. Prosecutors often, at least as far as India is concerned, what we have as the office of the prosecutor, often it is appointed on political considerations. You are in this party today, you have a prosecutor, and prosecutors spend n number of hours not prosecuting cases, but they try to see how they can utilize the mechanism, the system, to make sure that they have better briefs when they finish their term. And so you were saying that you don't get good lawyers to prosecute. We have a barrister from Hong Kong today. He can tell you what is the kind of salary that the Hong Kong administration provides to prosecutors today, as opposed to a private practitioner would be able to make through private practice. It might not be at par, but it is not bad. In India, it is a petty amount that you won't be even able to buy a decent cup of coffee for the amount of money that you might get to prosecute a case in New Delhi, for example. I'm sure it is the case in Kerala, the state where I come from, and it is different from state to state. So if you pay peanuts, today the circumstance is that, sir, we don't even get monkeys. So if we need to get good prosecutors, we need to pay them better. I was a lawyer, I went to court, I practiced for 10 years. The reason why I did not opt to become a prosecutor, because it is a no man's job. It is a place where people who get nothing else to do, who can lobby, who can surrender your spine to a particular political party, you get appointed as a prosecutor. I was not one, so I was not a prosecutor. Even though I was appointed as a special prosecutor by requirement of the court on a couple of cases, which I prosecuted because I was sure that this is a case where I can do my job. But otherwise, I did not want to become a prosecutor. I never want to become a prosecutor if I were to go back to practice, because it doesn't pay. Much worse, that I am destined to deal with a bunch of papers that is considered to be the case diary, which is presented to me, which I am sure that the police must have obtained by use of torture, just implicated because of political reasons, and so many other things. But for the only thing that might be missing in that will be a reasonable ground on which an accused can be actually charged with a crime. Everything else will be there in the case diary. The reason for charging someone would not be there in the case diary. So I don't want to be a prosecutor. So we won't have conviction rates. You won't have, if a witness, now we talked about witness protection yesterday. It is also in the convention. It is also covered under the sweep of Article 2 of the convention. If a witness need to go back and forth for a criminal trial to complete for the next 10 years, if I witness a crime, I would not want to speak. Because 10 years, my life is in absolute soup. Neither am I provided any kind of protection if I were threatened. So these are issues, much more. We can debate on this endlessly, but I think I should stop. So Article 2 is a convention that can be deconstructed word by word to see what it actually implies, how it translates into our daily reality. Convention is not, it sets a norm, it sets a principle. It is not something that we have to blindly apply to our domestic municipal jurisdiction. We have to introspect, we have to bridge what is there or what has been said and what has been practiced. And until and unless we start debating about what is the actual practice as opposed to what is supposed to be done, we won't move an inch forward. We going and ratifying a convention. I would be happy if India doesn't ratify a convention, but it does something to reform its police, our policing system. I would be happy if we have if you reduce the delay in court trials from 10 years to 1 year, even if India doesn't ratify the convention. And if rest of the things are okay, it doesn't matter for the government whether it ratifies or not. So there are other articles. I will start skipping this, some of these articles unless it is something very essential to be pointed out. You know, the principle of refoulement and so on. Article 4 is what warrants that torture is a crime in the criminal law of the country. Information, training of people, and so on and so forth. Now, it is getting revealed in the Indian context that the government instructs law enforcement agencies to engage in acts of torture so that the message is sent to political groups, to politically dissenting groups, to communities at large. We can see torture, use of exceptional forms of violence used against selected communities, Muslims in particular, in India, to send the message that if you ever come across any opportunity to be what is called a jihadi or a Islamic fundamentalist, or if you want to make your first initiation into that direction, beware that this is what is in store for you. So they pick and choose people who are suspected or who are accused for n number of reasons to be Islamic terrorists fighting against the government of India, and they brutalize them. So training of law enforcement officers in modern India today is the other way around than what has been said in the convention. Review of interrogation procedures and so on and so forth. One of the issues I will, you can go through the convention article by article if that is what you would want to do to understand more about the convention, because it sets norms, and I think the most important things are concerning how torture is defined, how it need to be dealt with by law and also by procedures in the country, and how the non-acceptance of evidence by confession is declared by the convention. Legal system. I mean, we can have a separate seminar actually to describe and explain about how our legal system does not function or do everything else. Iran was emphatically referring yesterday about independence of institutions. It is a real problem in many countries. I think in Pakistan too, that becomes a big issue where the independent nature of the judiciary is overshadowed by overwhelming military interferences and sometimes also political and religious interferences. So, I mean, torture, black and white, or the use of torture, the criminal trial, black and white, sets a precedence that, well, what is accepted is what is accepted in law, and it stands the test of proof. Whereas torture simply, washes the entire argument off. So Article 14, which ensures about the legal system, which calls for the legal system to be perfected to deal with the menace of torture, we have serious concerns regarding that. In fact, in all the countries that are represented here, making a complaint against torture is the biggest challenge. People from India, civil society organizations from India call AHRC and expect us to issue an urgent appeal so that the urgent appeal could be used as a complaint, because if they go to a police station, the complaint is not accepted. Or if they go to the court, it is almost impossible for the complaint to get any further or go any further. Okay, one more last thing that I wanted to highlight is the presence of the CAT committee. Many of the countries here has not ratified the convention where the jurisdiction of the CAT committee is accepted. It is a treaty body mechanism. It is a committee of independent experts appointed by the states who can accept complaints from individuals, from civil society, from the state concerning an act of torture. It can call for opinions from the government as to the facts alleged in the complaint. It can sit on inquiry and can decide the case and recommend to the state what remedies that it should take on that particular case, what protection that the person should receive in that particular case. So that is a treaty body mechanism that is available within the CAT, and it is considered internationally as not a biting dog as such, because it is very soft, and it is one committee like this is one of the reasons why generally jurists sometimes argue that international law is soft. I disagree, but regarding CAT committee, maybe it might be partially true that it has made a lot of interventions, but then of course the states doesn't follow. We, of course, not from the CAT committee, from the Human Rights Committee, we had contested a case, many cases, of which one case was from Sri Lanka. The committee gave the directions to the government of Sri Lanka to, how to deal with in the case. But then the Supreme Court of Sri Lanka said that, well, the jurisdiction of this court cannot be subjugated under the jurisdiction of the Human Rights Committee. The government just completely ignored the Human Rights Committee recommendations at that time. Now it has started ignoring and have managed to deal with the Supreme Court itself. So when you have, yesterday we discussed about the fiction of law that creates independent institutions. If that bubble is pricked, if it is broken, then there is no space for observing the decency of what the court decrees and how the government is supposed, one of the parties to the litigation, which often happens to be a government in a torture case, need to follow. And if the government simply decides that, well, we don't care, then we have a big constitutional crisis. It's actually a constitutional crisis. It's a political crisis that we are discussing about when we discuss in deep about the practices of torture and the institutions that allow the practices of torture. I think I should stop here. I'm sorry that I took 20 minutes more than what I was allowed. Thank you, Basil, for bearing with me, and thank you all. Thank you.